Some of the most common contract disputes we see in the construction industry have to do with non-payment on a project, disputes over change orders, and then a lot of the time delays in the work, schedule delays, things like that. So the best way for any subcontractor, general contractor, owner to protect themselves when it comes to change order disputes, construction delays, payment disputes is really it all stems from the contract. You need to have a solid base. And that a lot of the time requires an experienced attorney to review that contract. The language in every single contract is completely different. I've yet to see two contracts that are exactly the same. The payment provisions could be completely different. What the contractor is required to submit to the owner for proof of payment, when payment is made, when the application for payment submitted, what the owner or what a contractor can dispute in the payment application could be completely different. So when you have an attorney review it, you can make sure that an attorney drafts or modifies the language to best protect what it is that you need to be protected from. So, depending on whether you're the owner, developer of the project, you're the prime or general contractor, or the subcontractor, you actually want different language based on what hat you're wearing. Obviously, the owner's looking to be protected on, delays because they have a project that they're trying to get open. They probably have tenants that they're trying to collect rent from, and they can't do that until construction is completed. You're a general contractor. Obviously, you want language that protects you if something outside of your control happens and you need a extension of time on the contract. So where an owner would want something that says, hey, no, this is the substantial completion date, you get it done by this date or you get hit with damages, a general contractor is going to want something that kind of says, hey, yes, but if there's a delay beyond my control, I want extra time to complete the contract.
There was an issue several years back. One of our clients had already secured the job, started, and then delays started by the owner. The owner tried to blame the city for the delays and point the finger, but the delays continued for months and months. And during that time frame, prices went up. For example, fuel prices just to grade the property went up almost $300,000. And if the project had moved forward under the terms of the original contract, it would have put our client out of business, our general contractor. So we were able to find within the terms of the contract some language that said if there were so many consecutive days of delays that we could back out. And ultimately, we did save our client's business. We were able to back out of that original contract, and they were able to come up with new terms. They then all got along, and the project, I believe, is near complete now.
Yes. And see, and that's a prime example of the owner and the contractor kind of having different positions and what that delay language could be. In that situation, someone was going to get hit for over $500,000 in delays. So either the contractor was going to have to eat that increased material cost, that increased labor contract cost, or the owner was going to have to pay those costs to the contractor. And that's why, depending on what position you're in, you definitely, no matter what position you're in, actually, you want to have an attorney review it so the language is as fair or as favorable to you as it can be.
And we were getting calls by the owner's lawyers out of state from New York, do you realize who you're messing with? And ultimately, we prevailed on behalf of our client, the contractor, and got everybody back to work and got everybody paid based on what the material increases were. Because again, it would have cost them millions of dollars had they had been bound by the original terms of that contract.
Well, I mean, what I can say is I've reviewed construction contracts that are 100 plus pages long. And as you can imagine, in a 100-page plus contract, there are so many different things to watch out for, so many pitfalls there could be. There could be conflicting language in, different sections of that exact same contract. And a lot of the times there ends up being conflicting language. So, I mean, I can't give you a number of pitfalls because they're countless, they're endless.
Well, one of the pitfalls too that we've encountered is the contract will say you have to go into mediation. And before you go into litigation. And mediation means, oh, let's all work together and see if we can settle it. Well, clearly you're not going to resolve it because there's already a problem. So that mediation could take time. It can take another $15,000 to hire a mediator. And then it says, well, if mediation fails, you have to go into a binding arbitration. And binding arbitration means you don't get to go to a superior court and have a jury hear it. So there's lots of different things, but sometimes you've never waived that right to a jury trial, but they have the language in there anyway. So you have to have a lawyer then to come in and say, wait, we can overturn this particular provision or language in the contract to the benefit of the client.
A big one that we see in today's climate with, tariffs, we had things shut down during COVID, is an issue on material price increases. That seems to be a more common trend. Obviously, owners don't want anything in there for material price increases, but it's something that's really important to general contractors and subcontractors because these projects, they're not short 3-month projects a lot of the times. Some of these major projects could take a year, 18 months, 2 years. And so, when you're a subcontractor or general contractor and you entered into that contract a year and a half ago, and now they're just asking you to get started, well, as we all know, inflation, material prices increase significantly over short periods of time sometimes. So you as the sub, if you're bound to perform the work under that original contract amount, it very well could put you out of business. One thing I'll advise every contractor out there is to make sure that you know your deadlines when it comes to mechanics liens. So there's a couple things to be aware of. One, there's a deadline in which you can file a mechanics lien on a project. You only have so much time after the work's been completed or after a notice of completion. Then once you have that mechanics lien filed, you only have so many days to enforce that mechanics lien. And by enforce that mechanics lien, I mean file the lawsuit in order to foreclose on a mechanics lien. Just recently we have a new client who contacted us the day of the deadline to enforce the mechanics lien. Call came in after lunch as well. So we had a few hours where we had to get the information, review the contract, review change orders, review pay apps, and get it filed. Now, the client in that situation actually tried to file something themselves with the court, some form that they had found online, and the court actually rejected that because it was not a proper complaint or pleading. So, that's one of those big ones. If you're on a construction project and you've gotten to the point where you've had to file a mechanics lien, the sooner you reach out to an attorney, the better. Because if you miss that deadline to enforce your mechanics lien, your lien rights are gone. And your chances of collecting from the owner are next to zero.